Hello, I'm John Vanderloo, Editor of International Employment Lawyer, and thank you for joining today's webinar on executive compensation trends. I'm pleased to say this is proving to be one of our most popular webinars to date, and there are a lot of new names on our delegate list today. With so many of you being first-time attendees, I want to take a quick minute to properly introduce you to International Employment Lawyer. IEL was launched in February last year with the aim of delivering timely reporting, data and analysis of the latest trends and developments in the management in multinational workforces. We are steered by an editorial board of leading cross-border employment lawyers who help us to produce in-depth stories on the challenges facing employers around the globe. If you haven't already done so, then please consider signing up for a free IEL account, and we look forward to becoming a staple of your daily news for years to come. Back to today though, and as the so-called Great Resignation accelerates the war for talent and younger generations demand more from their employers, global businesses should not overlook the continued importance of executive compensation plans. Compensation remains one of the major drivers for senior staff retention and recruitment, but also a key driver for disputes. So we're very lucky today to have an expert panel of literary lawyers who will compare the executive arrangements and disputes from across the US, the UK and European markets. I don't need to tell you that Littler is the largest employment law firm in the world, who are absolutely experts in what they do, and it's great that they're here today to give us the lowdown on what we can expect this year and the years ahead in the compensation space. Before I hand over to the panel, there's a few quick housekeeping points to cover. First, please use the online question tool to post any questions you might have for our panel, and I will share them in the Q&A session after the presentation is complete. Second, if you have any audio or visual problems, please let us know by using the question tool as well, and a member of our team will be on hand to support you. And finally, please note that today's session is being recorded, and we will share a copy of the recording via email and on our website in the coming days. Without any further ado, I'll hand over to Darren to begin the presentation.
Thank you, John, and thank you everyone for joining us today. My name's Darren Isaacs. I work with Littler in London, and I'm joined today by a panel consisting of 4 of my colleagues who I'll just introduce you to, and we're going to talk about employers not forgetting about executive compensation in the context of the Great Resignation. So I'm joined by Phil Berkowitz, who's from our New York office, Christoph Crisoli, who's in Frankfurt in Germany, Dennis Veldhusen, who is from our Netherlands office in Amsterdam, and my colleague in London, Alison Snedden. I've also got a few housekeeping matters. The first one being that this is obviously a live session. Some of us are still working from our homes. We will do our best to keep toddlers, cats, dogs, and so forth, street noise to an absolute minimum, but please bear with us if something random happens. If you do have any questions, as John said, pop them into the box and we will do our best to deal with them at the end of our session today. We'll talk for 45-50 minutes. That should leave plenty of time to get through a number of questions. If we can't get through to your question, then if you email us afterwards, we'll be very happy to follow up by email. We have around, as I understand it, 1,300 odd participants today. Most of you are based in the United States, but not everyone. So we have tailored our presentation to that, and it should be, it's pitched for a relatively broad audience. So everyone is welcome. Just waiting for my slides to catch up. There's our panel. Right, so today I've done the introduction part. We're going to use a case study, which is going to frame the rest of our discussion. It's a panel discussion today. It's a moderated panel discussion. So I will be moderating. My other colleagues will be pitching in. We're going to talk about a number of the issues that relate to executive compensation, particularly in the context of a resignation. These are the issues that we see come up time and time again. At the end of it, we will circle back and I'll ask each of our presenters what their key takeaway is from today's session. And then, as I said, after that, we'll have our Q&A. Okay, so on to our case study. The case study is Cheryl and A to Z Core. A to Z Core is a New York-based company, and it's hired Cheryl Ross as their managing director. She has a very busy job. She's going to be managing their subsidiaries in Amsterdam, Frankfurt, and London, spending her time roughly split equally between those 3 centers. As if by magic, these are also the 3 centers that we have experts joining the presentation today. Now, Cheryl negotiated her employment terms before she started working for A to Z, and the key ones we're going to deal with, I've put on the next page. In the meantime, let me just tell everyone that all of Cheryl's employment documentation is said to be governed by New York law, with New York courts having sole jurisdiction. We've seen this sort of thing many times before. Now, the key terms, compensation, annual target comp of US $1 million, and that's split in half. Base salary, 50,000, sorry, that should be, it's 100,000 US dollars, 50,000 US dollars base salary. Variable pay, also $50,000, split half between an annual performance cash bonus, which is said to be discretionary, but with some targets, and a 25% going into a long-term incentive plan, which will be delivered in RSUs, restricted stock units, which is so half the variable pay in cash and half in RSUs. Now, there are some conditions. The variable pay elements, the cash bonus and the LTIP, are both subject to a vesting schedule. The employee, Cheryl, must be in employment and not working through a notice period when she gets her variable compensation. So if she resigns before the money gets paid out or the LTIPs get delivered, she doesn't get them. And secondly, there's this clawback arrangement where if the employee resigns, she has to pay back any variable compensation from the year before, is the bottom line. Quite a harsh clawback. There's a termination provision which says that if Cheryl wants to move on, she needs to give us 6 months advance notice. And if we want to fire Cheryl, apart from gross misconduct, we would also need to give Cheryl 6 months. And there is also a garden leave clause. And for those of you who are not familiar with garden leave, it's essentially, it's an English UK type of clause which has started creeping out into other parts of the world, which basically says that once an employee is either told they will be leaving in 6 months or gives 6 months notice of the resignation, the employer can make them sit at home and not do anything out in the garden, which is why we call it a garden leave clause. And by doing that, you effectively, as the employer, keep them out of the market for the entirety of their 6 month notice period. Now, what happens next? Well, Cheryl resigns to join a competitor. She's had enough. She has decided to avail herself of the Great Resignation, and she's going to do something different. She gives us 6 months notice of her termination in accordance with her employment contract. She's then placed on garden leave for her 6 month notice period. Now, during this time, she just sits at home. She doesn't have any active duties to do, but she just waits it out. She's just at home for 6 months. She is still on the payroll. And because she's still on the payroll, this takes her date of termination to after the close of the company's variable compensation year. However, A to Z Core doesn't pay Cheryl her coming variable compensation, either her annual cash bonus or the next installment of any LTIP shares, RSUs, because it says that she resigned before the award date, even though she technically remained an employee until after the award date. Under the terms of the documentation, she wasn't entitled to receive anything. The company also wants to claw back what Cheryl received the year before, because even though they've already paid it out to her, they say that because she's now resigned, she's triggered the clawback and they want their money back. Cheryl obviously wants her variable awards for the coming year, or for the year that's just gone, the ones that are due, and she also doesn't want to return any variable compensation that she was paid in the 12 months previously. So this is our fact scenario. And what we're going to do today is to use that as a launching pad for me to ask a bunch of questions and for us to have a panel discussion about some of the issues that we typically would see come up in this scenario. So first of all, I want to talk about setting the scene. I want to sort of set a baseline. And Phil, I'm going to ask you, if you wouldn't mind, can you just talk us through some typical executive compensation elements so that we know, what we're dealing with here?
Yes, sure. Thank you, Darren. And thank you, everybody, for being here today. I did just want to spend 10 seconds, on, you mentioned garden leave and the fact that she's at home and she's not working. She actually can't work for anybody else while she's on garden leave. It's sort of equivalent to a non-compete in some ways. And in the US, courts are beginning to understand these, but they're often mistaken for non-competes. They're different animals. but that's a whole other discussion we could have for another day. But anyway, so Cheryl is on garden leave, and I've been asked to just identify the basic types of compensation. And the types of compensation across borders are largely the same. But as you'll hear today from everybody, the rights of employees often differ significantly depending on circumstances. So we'll start with base salary. Of course, base salary is often a substantial amount, or if not the majority of compensation. But for many executives, base salary may not be the majority of compensation, and instead their compensation may be, or the majority of their compensation may be at risk and receiving it under different sorts of structures. So for example, after we talk about base salary, which everybody understands is just your salary, which you probably receive every month or every 2 weeks, you might be eligible to receive a bonus, a short-term incentive, which might be an annual bonus. Normally, a bonus is your ability to receive the bonus depends on several factors. Will the company achieve certain short-term business goals? Will it increase its revenue or market share, improved profit margins? So the bonus may be based upon, in part, how the company is doing and whether the company meets certain goals. On the other hand, the bonus might also be based upon an individual's production, which may be specific targets that the individual or perhaps the individual's team has to meet. So the bonus may be based upon companies meeting certain targets, the individual meeting certain targets, or in many cases, the bonus may be discretionary, or the company may claim that the bonus is entirely discretionary. And sometimes, as I think is the case here with Cheryl, it may be in part discretionary, and maybe half of it may be discretionary and half of it may be based upon meeting certain targets. So that's a short-term incentive. And then there are long-term incentives, which often do account for, again, a very significant part of executive compensation. These are long-term incentive programs are often provided in the form of stock-based compensation, stock options, restricted stock, performance vested stock options, or similar devices. There is often a vesting period, which may run between 3 and 5 years, with the individual not receiving any pay until the end of the particular tranche, the vesting periods. And the goals vary by company, but again, they often take account of how well the company has been doing. There are statutory benefits like Social Security. There are other benefits like deferred compensation schemes, like in the US 401k plans, which allow executives to voluntarily defer salary until later dates. Other kinds of long-term incentive plans include non-qualified stock option plans, which the most common of which is among publicly traded companies is the non-qualified stock option, where participants are granted a right or option to purchase stock from the company at a specific price, usually the fair market value. The option continues over an extended period, and then the individual can exercise or can sell the stock at a future time when the shares are valued at a higher market value. There are other types of long-term incentive stock plans, restricted stock grants, where organizations that don't have publicly traded stock may provide phantom stock arrangements where the value of a hypothetical stock is linked to the book value of the organization. In private equity firms and in hedge funds, often a very significant part of compensation is carried interest. And that is where these folks develop these funds, and they receive, at least in the United States, and a favorable tax treatment, capital gains tax, and they may receive up to 20 or even 30% of the profits that are created by that particular fund. So those are the key kinds of compensation and that we're going to be discussing today. And Darren, I didn't know if you wanted me to talk about the major changes that we're seeing in executive comp at this time.
If you have some quick observations, by all means, Phil.
Yeah. So one of the questions we received from prior to the presentation today was somebody asked what are the major changes that we're seeing in executive comp over the last year or two. And I think, and we all discussed this in advance of the program, and I think that we're in agreement that essentially COVID, of course, has had a significant impact on compensation. And on the one hand, there's a need with the Great Resignation that Darren referred to before to provide certain handcuffs to people who may choose to quit. And so the hope is that you have a well-written plan that makes clear that an individual may or may not be able to bring certain compensation with them when they leave. On the other hand, the competing interest is keeping people and enhancing benefits. And so companies are trying to put in place programs that do incentivize people to stay. And the other issue is that, a lot of companies have had difficulty meeting targets over the last year or two. And how do we compensate people in those circumstances while wanting to keep them around? So I think those are the key things that I've seen.
Thank you. And then Alison,
sure.
You'll see question number 2. Are there any regulatory considerations? I just want to touch on this so that we don't miss it, but I know that that's not exactly what we're talking about today.
Yeah, exactly. There's 2 things to be mindful of here. One is if you're in a regulated industry, in particular financial services, there are quite a lot of restrictions around what you can pay as bonuses and also the different types of bonuses that you can offer. So that's an area where you have to pause and make sure that all of your documentation is up to date and in line with those requirements. The second is public companies. They are obviously open to a lot more scrutiny around what is paid to employees, and there's broader considerations in terms of the input from institutional investors and shareholders.
Thank you. And then, Dennis, picking up from what Phil said, can you talk us through what some of the more common metrics are that are used in variable compensation bonus schemes and so forth internationally?
Yeah, thank you, Darren. What we see in Europe is that I think the common criteria metrics for eligibility to compensation schemes include job category, length of service, mostly job classification, but of course also the goals of the incentive, what the payout of course will consist of. Are we talking about bonuses, stock, cash? I think generally in Europe, bonus plans are based or generally based on business project goals as well as individual targets rather than full discretionary bonus schemes. Alison, can you weigh in here? How does it work for the UK?
Yeah, exactly. For discretionary bonus schemes in the UK, there is quite a lot of flexibility for the employer in terms of applying a discretion. Generally, you have quite a broad range, though you need to ensure that you're not exercising that discretion in a way that's irrational or perverse or in a discriminatory way, for example, towards an employee. And in terms of how flexible you can be with the schemes and how negotiable are those models and bonus metrics, anyone who's worked in HR will have probably come across someone who's trying to negotiate a bonus on entry. And there's 2 things to think about here, and I think this applies internationally as well. The first is, as a business, do you actually want to be flexible with this? And that's bearing in mind that you will have a scheme in place that applies often group-wide and to a number of employees. So there is an issue if you are treating someone inconsistently in terms of broader employee relations and questions that might raise. The second is, can you actually make those changes? And again, this goes back to the point that There may be restrictions from a regulatory perspective, or if you're a public company, in terms of how flexible you can be. What we tend to see is that you may be able to negotiate individual metrics. So for example, you might have a commission scheme that's got a very clear document in place as to how it works and how the payout operates, but it might be that there's some flexibility around negotiating individual targets in that. And I also think another one to be really mindful of, and which is quite an easy one to explain to employees where you have lacked flexibility, is if you're operating a global plan, a share plan, for example, or a long-term incentive plan, you are just not going to be negotiating the individual language of that with one employee. It's probably been quite a long-term project involving international lawyers to get that in place in the first place.
Great, thanks
you. Alison.
I think that yeah, if I may continue, Darren, just for a few seconds, I think looking at the Europe, I think landscape, it's basically quite important to be very specific, right, on how do you measure bonus performance, how do you calculate bonus earnings, does the bonus plan govern prorated payment, or should the employee remain employed through the payment date of the bonus, and also discretionary power clauses saying we may take into account other elements, etc., should be very specific. That's I think what we see in Europe, and generally, I mean, it's the business that make their own metrics, of course, and I'm glad about it, because it's not the lawyers that do that, but that can generally cause difficulties in practice, right? So looking again at the European employment environment, is basically advised to use proper target setting. In other words, define SMART goals. I think it's Christoph that will further detail that. And then lastly, I think when it comes to which types of incentives are applied, I think internationally we see a focus on longer term deferred incentivization, like tax-friendly RSU, LTI plans when possible, rather than cash bonuses. And these are performance or time-based employee equity, sometimes even connected to a company's exit, that have gained popularity, I think, in Europe, specifically when it comes to startup companies. However, at the same time, I think we discussed it with Christoph when doing the preparation. I think we also see that it's sometimes culturally determined that other countries like Germany, for example, still prefer cash-based plans rather than equity-based plans. So that's basically what I wanted to say, Darren.
No, thank you very much, Dennis. So I feel like what we typically see is a whole spectrum of variable compensation arrangements. So at one end, you've got some which we do quite like in the UK, Alison, which is we may at the end of the year give you something in our absolute discretion, and it's not for you to ask how or why we do it. In other cases, you have very clear goals and metric-driven arrangements like sales commission plans and what have you. And then sometimes you have this weird hybrid, which is it's primarily looking at goals and outputs and metrics, but we reserve some discretion to do something different. So I want to now come to you, Christoph, and I want to look at the question of how European courts in particular deal with employer discretion, metrics, clawbacks, all of these things that we see, quite often we see in some US-based documentation. We embrace that a bit in the UK, but it doesn't always work out so well on the continent, right?
It does not, generally speaking, Darren. Thank you. And I have 3 short points and principles from a European perspective. And the first principle is that, in general, bonuses in Europe are not discretionary, even like when in our case a contract says they are. And the main reason is that bonuses are regularly linked to targets, whether these are individual or financial. And the bonus is a compensation for the attainment of these targets and nothing else. So when targets are met, either partially or fully, there is no room for discretion, and a business could not argue that the bonus is actually a present that can be withheld, for example, because there is no funding, or that the bonus period has not been met because the employee has left the business before the end of that period, or the employee has not been fully loyal to the company. That's the first principle, and that leads us to the importance of proper target metrics and proper target setting. And this is key for legal and financial safety. It is the employer's responsibility to take the initiative to set targets or initiate an arrangement on targets, and then to evaluate the attainment. And it is essential in Europe that this is taken seriously, because in the absence of proper targets, the employee can claim compensation for the fact that he or she has not been provided with the opportunity to achieve targets and earn a bonus. So European courts, to answer your question, will often award bonuses on the basis of hypothetical reference standards in the industry and an assumed attainment rate. So, Dennis, the best strategy to adopt for an employer are the so-called SMART principles, which means that targets need to be specific, measurable, achievable, realistic, and timely. And in the times of COVID, we have expanded that principle to the SMARTER principle, which adds the principle of evaluation and readjustment. It's a bit like a pilot who needs to readjust his flight path or the flight path of an aircraft during flights. And so this, if you look at the SMART principles and if you adapt these to your business, you should be very safe. Also, as you know, Europe does have collective agreements with unions, with employee representatives, and we also use these smarter and smarter principles very often. The third point are share schemes, and they are a challenge in Europe for a different reason, and that is called the civil law principle of contractual transparency. And that principle says that contractual arrangements must be clear and unambiguous and balanced from an employee's perspective, not from an employer's perspective. And we see share schemes that are often not only very lengthy, but complicated to understand for employees and contain terms that may not meet the standards of transparency. And that includes clawback, good leaver, bad leaver, and forfeiture provisions that European courts may find and will find intransparent. And in such a case, a court could read the share scheme as if it has been agreed without these clauses and award an employee a compensation as if the value of the shares had not been influenced by these clauses. So these three principles for Europe, very different as we see, but still, I think, relevant in practice.
All right, thank you. So let's now move on. Just wait for my slide to catch up again. What are Cheryl's options? Cheryl's still not happy that she hasn't got her variable compensation, and also that the company keeps writing her a letter saying last year's variable compensation has to be paid back. So she's ready to sue. So I guess question number one, Phil, help us out here. Where's Cheryl going to be able to sue? The documentation's got New York law written all over it. New York law, New York courts, New York, blah, blah, blah. Is that the end of the story?
Well, I mean, from the perspective of a New York court, the answer is likely to be yes. I think that in this kind of circumstance, you know, I think our European colleagues might better be able to answer the question as to whether a court in, you know, in the UK or in Germany or in Amsterdam would enforce a a choice of law and a choice of forum clause as we have here. We have an individual who was hired in New York, presumably still has contact with New York, but is now living in Europe. What I might recommend that the company do in a circumstance like this, if we have a sense that she's going to bring a lawsuit, is to sue her first in New York, seek a declaratory judgment as to what her rights might be. I mean, the amounts here are so small that it's not likely that there would be a lawsuit, but certainly if you wanted to try to preserve New York as the forum, it could be that a court overseas would be less inclined to interfere if there was already, you know, a New York court is likely to be considered to be reasonably likely to handle a matter with appropriate due process by the courts of the UK and Europe. You know, in terms of, she might or might not be able to keep her claim in New York if she wants to. Does she want to be in New York? Maybe is also your question, Darren. And what would the New York courts do with this? I mean, and I think it's important to recall that we're talking about New York. The United States, of course, has 50 states. Every state is quite different in terms of how they consider these issues in terms of compensation and bonuses. Generally speaking, in the US, compensation is based on contractual agreement. And if your agreement is not clear, then a court is likely to determine that it should be construed against the drafter, and the employee may be able to prevail. Here, you know, Cheryls' agreement says, at least according to what we've got in the PowerPoint, I haven't seen any written agreement. It'd be nice if it were in writing, but it says that there's a discretionary bonus which is subject to company and individual targets, which is kind of an inconsistent notion. In order to be able to demonstrate that a bonus is truly discretionary and that the employer has the right to withhold it, there normally should be statements, strong contractual language that makes clear that the individual does not have a contractual right to the bonus. There should not be a formula, because if there's a formula, a court is likely to say that the individual has earned the bonus. You want to make very clear that there's no vesting of the bonus until it is paid. You want to make very clear, of course, that the individual must be present in order to receive it, as I think is the case here. So, but even with those particular, with that strong contractual language, that might work in New York. But if you were to look at other states around the country, there are limits on, for example, if she resigns, maybe you can restrict it. But if you terminate her in a workforce reduction, the employer may not be able to enforce those kinds of provisions. So she may want to be in New York, but then again, based on what I've heard from Christoph in terms of the idea that discretionary bonuses are just often not recognized, and the idea that the employee earns it, she might prefer to be in Europe and take her chances there.
Well, let's just say she might prefer to be in Europe, because it sounds to me particularly like the European judges in the European courts are not really into this discretionary concept at all, really. So Christoph, Dennis, Alison, if she goes to a court in any of your countries, what's going to happen? Is the court just going to say, no, you can't come here, go to New York because the document says New York, or is it not that straightforward?
Well, if I may start here, I mean, it's not that straightforward, because the bonus plan or the RSU plan is obviously linked to the, in this case, Dutch-based employment contract, right? So,
right.
And that is, I think, so generally a judge will say, hey, I'm happy to rule on the case, and I'm allowed to rule on the case, right? If you, I'm not sure how it is in Germany and UK, of course, but I think she could be quite successful in Amsterdam.
Yeah, Alison, can we lock her out of the UK courts that easily, the UK employment tribunals, or is it, you know, anything to say?
It's not. Exactly, it's not that simple. There would be a similar analysis as to whether or not there are any claims that she could bring in.
Yeah, and Christoph, I'm assuming it would be broadly the same in Germany. She may well be able to go into the German courts.
We do have regulations on judicial venue in Europe, and I would say that, yes, clearly she could bring claims over here, not a problem.
Okay, all right. So
but,
she may
a court in New York could very well enjoin her from going to another court and penalize her.
Yeah, maybe
If
get
she
in
does.
first if you need to
Yeah.
have that fight. Maybe go to the New York court first, and then it starts to get very complicated with a New York judge saying, Cheryl, you can't go to another country, and then a judge in another country saying, possibly we don't care what the New York judge has to say, and then Cheryl's stuck in the middle, wondering what on earth she's going to do and where she's going to get the money to fight multiple cases on multiple fronts. Okay, right, so types of claims. So am I right in thinking from the discussion so far, it's primarily, what we're talking about is primarily some sort of argument about the reach of the contract or the agreement or the plan rules or whatever, it's how they're interpreted, whether the discretionary elements in those rules apply. I suppose potentially there might be other statute-based claims. Unlawful withholdings from wages seems to feature in a lot of US state law, also in the UK. There may be some, she may allege there's some form of discrimination or whistleblowing and she didn't get paid for that reason. Is that anything to add from the other countries? Is that essentially it? Hitting the hammer on the head, the nail on the head?
Well, go ahead, Alison, sorry.
Exactly, that's the key things we'd be looking out for. We've not heard anything in this case study yet about discrimination or whistleblowing, but when someone hasn't received large amounts of pay, I think we can expect that we might see some of those issues being disclosed, at least in a complaint, which would mean we're less looking at the contractual language and more about the reason for the non-payment.
Okay, well, just following on from that, one thing we do often see, and we do often, US-based employers quite like to put in, is an arbitration clause for perfectly good reason. So, Phil, this is quite a normal thing for the US, for US documents. It may not be completely, commonplace or whatever, but it's not unusual, right?
Yeah, I do just want to say one thing before I get to that, which is
sure.
in terms of the contract here, this individual, Cheryl, there's a clawback provision, which says that if she resigns, she must pay back any cash bonus or LTIP award that is vested in the past year. That would be difficult to enforce in New York because it would likely to be considered, first of all, you certainly could not deduct it from her wages. That would be unlawful. And the courts in New York, there are regulations which say that even an arrangement which is similar to a deduction, which tries to get around the deduction, but requires repayment, may be a violation of the wage and hour laws. So you might even be precluded from suing her for that money, at least in New York. But in other states, you might be able to get to that. In terms of arbitration, arbitration is something actually that yes, there are very strong federal laws, the Federal Arbitration Act, which support the idea of arbitration in every context, and certainly employment disputes are no different. However, there have been very strong moves legislatively toward limiting arbitration, and recently, just in fact on March 3rd this month, President Biden signed a law which prohibits mandatory arbitration of sex harassment claims and sexual assault claims. So there are inroads trying to limit arbitration in the United States. Why do we like arbitration in the United States? Because the US is unlike any other country in the world in that we have jury trials to determine claims in civil cases, to determine claims for lost wages, to determine discrimination claims. So we like to try to avoid a jury, and we think that perhaps an arbitrator will have a more business-friendly view of things. That isn't always borne out by the facts. Arbitrators can and often do provide very significant awards, and arbitration can be extremely costly and expensive. So there are people who are on both sides of the aisle in terms of whether arbitration is a good or bad thing. What we often recommend instead of arbitration, actually, and this is enforceable in most states, is a waiver of jury trial provision. So the employee will agree as a part of their employment contract that if there's any dispute between them and the employer, both sides agree to waive their right to bring a jury trial. That way you're in court, you're not before arbitrators, but you don't have a jury.
Okay, well, that's interesting. We don't really have jury trials for employment disputes in the UK, but Alison, do we still see a lot of arbitration clauses? What do you say about that?
Yeah, exactly. They are partially effective in the UK, so you can still use them for managing contractual disputes. But when you get into the territory of statutory claims, so which in this example, we could see Cheryl bringing a claim for unlawful deduction from wages, you cannot require those to go through an arbitration. So Cheryl would still have the ability to bring that in an employment tribunal.
Okay, and
Yeah.
Christoph, Dennis, similar?
Yeah. Similar. We hardly see any arbitration clauses in employment contracts, and in any case, it will not stand in court. You can simply go to the labor court and put a claim there. So it's bring a claim to the court. That will the court will set aside the arbitration clause. Definitely. Yeah.
Same,
Agreed
Christoph,
for us.
Germany.
Yes,
same?
absolutely.
Yeah. Okay. All right. So I now, like any good Netflix TV show, I want to introduce a final episode plot twist, which is that instead of Cheryl resigning, we fire her, we being A to Z Corp, her employer, and we fire her because she's a bad fit, but that she hasn't done anything wrong. It's just not working out. You know, we've all been there before. So I specifically want to throw this to Christoph and Dennis, and then Alison, I'll come to you as well. But does this make any difference for her claims about unpaid variable compensation? Let's say, you know, we've fired her 3/4 of the way through the variable compensation year. How's this going to work out in your countries? Christoph?
Would make a very big difference, a fundamental difference, because her resignation safely terminates her employment, while a dismissal would not. In many countries in Europe, a termination requires some type of a justification. Some countries more, others a bit less. I can tell you that for some countries, including Germany, you may require a reason like Cheryl's position being redundant, or a longer sickness situation, or serious underperformance in some cases. And in the absence of such reason, Cheryl could claim reinstatement into her job, and that would effectively include back pay, including outstanding bonuses. So the financial risk of an ineffective termination is serious, and that is why we see that we see a risk there. And then, Dennis, I think it is even a bit more dramatic in the Netherlands, if I'm not wrong.
Yes, it is. It's quite similar, but we under Dutch law, the employer needs to have a demonstrated reasonable ground, redundancy, poor performance, to make sure that the employment contract ends. And if the employee is not willing to agree to an exit, you have to go to court and ask the court for approval to dismiss the employee. And it doesn't seem the case for Cheryl, because she's just fired for being a bad fit. That will not be enough, and that indeed means that she could claim reinstatement into her job, back pay of salary, bonuses, and invested shares or invested stock, LTIPs, and what you have. So that could be quite serious if you do it wrong.
So you're saying that the employer in the Netherlands can't just fire people normally?
Correct. We have this preventive dismissal system. So other than for cause, you need to have either the approval of the employee to leave the company, or you need to have the court approval to organize that. And that is,
and I guess,
lengthy and costly. Yes.
Yeah, so lengthy and costly, right? So tracking that through, if you go to the employee and say, we would like you to move on, it gives them quite a lot of leverage.
Absolutely. In this case, it means unpaid bonuses, maybe for the running financial year, unvested shares or LTIPs that would have vested within the next period of time, severance payment. That could become very costly indeed. Yes.
Yeah, and then Alison, I guess in the UK, we've got reinstatement as well, but we rarely see it, do we? It's mostly a compensation thing. So
exactly.
Yeah, similar dynamic in terms of leverage for the employee, but not quite as dramatic because they're unlikely to come back into the role. Would you agree with that?
Exactly. In the UK, you're less likely to have to deal with that awkward situation of the employee coming back. So really it comes down to assessing what compensation might be payable. Being a bad fit isn't generally a fair reason in the UK to lose your job. So if Cheryl has more than 2 years service, she could bring a compensation claim, or otherwise, again, if we're back to the discrimination, whistleblowing challenges, she may be able to bring a claim relating to that.
Okay, so ultimately then, it may not even matter what the bonus plan says or doesn't say, or the long-term incentive plan, because if Cheryl is trying to be moved on as the managing director of the Dutch subsidiary, for example, we're going to have a commercial conversation with her anyway, and she's not just going to let all that slide. Okay, so that pretty much brings us to the end of the formal part of our presentation. I just want to know what your key takeaways are, if having listened to the conversation. So Phil, what's your key takeaway?
Well, I mean, I think my key takeaway is that, first of all, we've talked about differences in laws, but difference in culture are also really important. And one thing that struck me when we were talking about negotiations, I mean, of course, the law may permit negotiations, but you have to take account of the company culture as well as the country culture. There are some countries where negotiating, if you're working for a foreign company in the US, where the idea of negotiating a bonus is viewed as perhaps even disloyal. So there are a lot of issues we need to think about beyond the law, and I guess that's where I'll stop.
All right, Christoph?
Yeah, so my key takeaway, Darren, would be please do not rely on discretionary variable pay. If you have a UK-based or US-based share scheme, try to decouple it from your local European employment and make it subject to UK and US laws by making the direct arrangement between a holding company, say, but not between the local employer and the employee. That should you bring into safer waters, but just be aware of all the risks that come along with the clauses, with these potentially unambiguous clauses in share schemes.
Okay, Alison, just quickly, because we're running over time, do you have a takeaway for us?
Yes, if you're dealing with employees that are working internationally or globally like Cheryl, you can't just rely on the governing law clause in the contract. It's possible that they could have employment rights across a number of jurisdictions. So something to take stock of before you go down the route of trying to claw back pay or dismissing.
Yeah, it is difficult with international employees. Dennis, any final words?
Yeah, just some final words. I think you use proper target settings and clear wording, define SMART goals in your executive compensation plans, and do not rely on discretionary power clauses, because it's very difficult to enforce them in Europe, as Christoph said.
You guys really hate discretion, don't you?
Difficult.
Okay.
Thank you.
All right. Thank you. Thank you, everyone, for joining the main part of our presentation. We're now going to open it to questions. John, are you coming back on to process the questions, or shall I take control of that?
I'm here if you would like me to be.
Yeah, go for it.
First of all, so we had some questions in advance. We had some questions during the session. So the first one is from an attendee who would be interested to know the impact on equity plans where local laws do not permit them. So how are companies making allowances for executives rehoming themselves to locations where equity is not available?
Okay, fair question. Can I just deal with that quickly? What I tend to see is that if it's just the one executive, will tend to modify it into a cash arrangement, and quite often it will be a phantom tracker plan. So it's like a phantom equity plan, and they just get a cash benefit. It's not as tax effective as a proper equity plan, but it's quite often the best you can do. Okay, Next one.
Phil touched on this earlier, but just in case anyone else has any other thoughts, are there any other big changes that you're seeing in the area of executive pay this year as opposed to in previous years, or perhaps in the future?
So Phil, you were talking about the impact of golden handcuffs and handshakes to deal with the sort of Great Resignation and return to work in other areas. Anything else from anyone on that?
Well, maybe just one sentence on the potential effectiveness of post-contractual non-competes. That may be a good instrument. They work in practice. They may deter employees from, leaving an employer, and they can be agreed for up to 24 months in many European countries. They are costly because the compensation can be up to 50% of the entire remuneration for that up to 24 month period, but that could also be a tool for retaining employees.
The other thing I would
works
add
very well in Germany. We would, I think the whole non-compete and payment and whatever is a really good topic for another webinar. Alison and I would fall off our chairs if we saw a 24-month non-compete, because you've got no chance of enforcing that in the UK.
Right.
But also we don't have to pay for it, whereas in Germany you do have to pay for it. So that's the trade-off, right?
You do have to pay for it to make it effective. That's the reason.
Exactly. Yeah.
I would add to that in terms of other changes that we've seen. I think that a major change that many of us have seen is as a result of the mobile workforce, and the fact that employees are now working remotely. They may be working in different places for different periods of time. I'm going to work in California for 2 months. I'm going to work in Texas. I'm going to go visit my Aunt Zelda in Zimbabwe, and so there are tax issues that come up. There are other, compensation issues that come up as a result of, are they in fact protected by local law? Are they governed by local law? Do we need to worry about the law in which they are, in the place in which they are working? So this is a thing we're seeing a great deal of.
Yep.
Right, John, another question.
Okay, next one quite topical, as it is specifically about the Great Resignation. So in light of pay gap reporting in the UK, pay equity review in the US, can an aggressive bonus incentive to onboard candidates in light of Great Resignation potentially skew compensation comparators when assessing equity? Anyone want to jump in on that one?
Well, I'm happy to offer some thoughts, but does anybody? I think from my perspective, the short answer is yes, but I mean it depends. It depends on what your local law on pay equity and pay equity reporting requires you to include when you're calculating the statistics and what have you. I think one thing that's very interesting that's related to that is that there are studies that I've seen referred to, but I've never penetrated them myself, which say that men are much more aggressive historically at negotiating harder on their way in, and if you find yourself in a situation like that, you have to keep a sort of strong eye on not onboarding a lot of male, more senior people, and by virtue of that, it's not the right word, skewing your pay equity statistics the wrong way, because you're not giving the women who you're onboarding the same opportunity. It raises some really interesting questions around that. So yeah, I think that is something you need to keep an eye on.
And that's something we've seen in practice with clients that have then had to take stock of the difference in pay gap between different genders and then almost do a pay equalisation process, which can lead to some very awkward conversations if you go back to, for example, a female employee and say, oh, I'm now magically increasing your pay by 20% to bring it into line with the rest of the group. So it's one to be mindful of, but I think if you're trying to attract key talent, sometimes employers will just go on and take that risk to get someone through the door.
Thank you. We've probably got one or two more questions, John.
So going back, I think, to the case study you've given, someone's asked, so let's say a US company adopts a 60-day notice period tied to garden leave. Practically, how does that get enforced when employees decide to give the standard 2-week notice?
So who wants to do with that?
Yeah, let me just try that maybe from a contractual perspective. If the contract says that the notice period, say 2 months to the end of the month, I would say that that prevails. It's a contractual arrangement, and that certainly overrules any shorter statutory notice period. In Germany, our statutory notice periods are relatively short, and if the contractual notices go beyond that, it's always the contract that applies, not if it's the other way around. So basically, that would be the answer. Yeah.
That would also be the same in the Netherlands. Yes. Okay.
And I would say, if I may, go ahead. I'm sorry. Somebody else.
No. You go ahead first, and then I'm going to say something.
Well, I mean, in the U.S., this whole notion of notice periods is, apart from financial services and in certain geographic locations like New York, I mean, it's becoming better known. But the idea of a mandatory notice period is quite contrary to typical practice and to recommended practice, quite honestly. Because it is very difficult to enforce. I mean, if you say to an employee, I want you to, give us 60 days notice of termination, that's simply not enforceable. Now, if you do couple it with this garden leave notion that you're going to pay them during that period, courts are increasingly recognizing that may be enforceable. But essentially, what you're doing is you're saying, you're imposing, what courts instead are saying is this is a non-compete, which may or may not be enforceable. And you can't simply impose a 2-month non-compete on an individual. So I would say that depending on the industry you're in, depending on the leverage you've got, it may well be possible to enforce that 60-day notice period when the employee gives standard 2 weeks notice. But if you're in an industry where this is not commonplace and you don't have a very solid garden leave provision, it may be difficult. And as a practical matter, how are you going to sue somebody for not staying the extra 45 days?
Okay, John, we've now gone slightly over time, according to the clock, the timer in the top right-hand corner. So shall we just leave it there?
Yeah, that's all we've got anyway. So many thanks to all the team at Littler for taking the time to be with us today. It's been a thoroughly interesting discussion. I've certainly learned lots, I'm sure you have as well. Just a reminder that the webinar has been recorded and we'll be sharing the recording online in the coming days. Thank you everyone for joining us, and we look forward to seeing another IEL webinar very soon. Take care and goodbye.
Thank you, everyone.
Thank you very much.
Thank you.